You are hiding the Epstein files, Mr. Patel.
The gentleman is expired.
You are part of the cover-up.
Can I respond?
You sure can.
Any allegations that I'm a part of a cover-up to protect child sexual trafficking and victims of human trafficking and sexual crimes is patently and categorically false.
A House Judiciary Committee hearing erupted when Congressman Dan Goldman accused FBI Director Kash Patel of withholding information related to the Epstein files. Patel forcefully rejected the accusation, arguing that legal restrictions prevent the release of certain materials. Watch the exchange first, then we'll break down what was argued, what evidence was discussed, and why the disagreement became so heated.
Mr. Patel, does Donald Trump appear anywhere in the Epstein files?
I'm sorry, could you say that again?
It's not a complicated question. Does Donald Trump appear anywhere in the Epstein files?
I didn't say it was a complicated question. I just didn't hear you, so my apologies. We have released where President Trump's name's in the Epstein files and everybody else, and all credible information that we are legally allowed to release has been released.
All right, so let's go through that. You're referring to court orders that prohibit you from releasing grand jury testimony under Rule 6E. Is that what you're referring to when you say as the law allows?
That's a piece of it.
Really? What other evidence do those three court orders you cited prohibit from being released?
Information that was collected pursuant to those search warrants that were limited
Wrong.
in fashion.
Wrong. That's not what the court order says, and that's not under 6E.
And you're talking, and I said that's 6E, and I said there was others, and I'm answering that there are sealed court order documents. There are protective orders.
They are unsealed as part of discovery given to Ghislaine Maxwell. They are no longer sealed.
That's just not true. We can argue about it all you want.
Okay, well, you agree that there are, so your testimony here is that the reason why you are not releasing all of the videos that you have acknowledged, there are so many, and that the FBI spent thousands of hours of reviewing, the photographs, the photographs that you have. You're saying that you're not releasing those because there's a court order requiring them to be sealed? Is that your testimony?
Never said that about the videos. On the totality of the videos, of the thousands of images that were seized pursuant to the search warrants executed at the time, the overwhelming majority of that video is pornographic material that was downloaded from the internet and child sexual abuse material. We will never release that.
Well, as you should not release the victims. But if there are videos that relate to others who Epstein trafficked to, such as maybe Prince Andrew, or photographs, that you have total control to release.
Yes, and if it exists.
And so why haven't you released it?
Why are you supposing that that is a fact when in fact it is false? Are you saying that
you're saying that none of the videos relate to anything relevant to the Jeffrey Epstein trafficking ring?
Every single video that we have collected pursuant to the prior search warrants has been examined for the last 10 years. And every single video has been utilized for whatever prosecutions were able to be legally brought.
I'm not asking about prosecutions. I'm asking about why you aren't releasing the full Epstein files, including the names of people who were involved in the sex ring that you promised to do before you became FBI director.
I just told you, I'm not going to release downloaded porn of
I'm
children
not asking
on the
about
internet.
that. Fine. I'm asking about all the other files.
What other videos? Tell me. Tell me.
That's what I'm asking.
Tell me.
You're saying there are no videos that would be relevant to anyone else involved in the Jeffrey Epstein sex ring.
Pursuant to Mr. Acosta's collection of information based on the search warrants. That's all we have in our possession.
And I'm asking you, that stuff.
That's all we got.
I'm not asking all you got. I'm asking you, in that stuff, there's nothing that's related to any other sex traffic, any other people engaged with Epstein in underage sex.
That's correct. To my knowledge, no.
Okay. Let's talk about the witness interviews. 302s of witness interviews. Those are not subject to the court order. Those are not subject to any fictional sealed order for a search warrant. Why aren't you releasing those with the redacted names of the victims?
We are releasing as much as legally allowed. That's why we went back to
how
the
is
courts.
How is that not legally allowed?
Sir, do you know how court orders work? Do you know how protective orders
Actually,
work? Do you know how
Mr.
sealing
Patel,
orders
I was
work?
a real prosecutor for 10 years. I know exactly how
so I was a
court
fake one?
orders. And I want to understand what the court order prevents you from releasing witness statements that the FBI took.
You should know that as a real prosecutor, when the court hand downs a protective order and a motion to seal, the material is sealed unless
So
that
your
judge
testimony
waives
here
it.
is that all of those witness statements are under a court order, a protective order.
We are providing everything we can legally provide.
No, that's not my
Congress has
question.
sent us a
My
subpoena.
question is, why are those witness statements that are not grand jury testimony, that if they were under a protective order are no longer under a protective order, why are they not being released?
How are they not
And
under a protective
Why
order?
are you not going to the court like you did for the grand jury testimony to unseal those
The
records?
DOJ did go to the court.
No, not on those records. Why
time
aren't
of
you
the
going?
gentleman.
You just went on grand jury.
Time of the gentleman has expired. The
You are hiding the Epstein files,
time
Mr.
of the gentleman
Patel.
has expired.
You are part of the cover-up.
Any allegations that I'm a part of a cover-up to protect child sexual trafficking and victims of human trafficking and sexual crimes is patently and categorically false, and the work of my
So I hope you will talk to them when they
Gentlemen's time
have
has
requested
expired.
to speak with you. Because
Gentlemen's
the
time has
victims have
expired. Gentleman
requested
yields
and you are
back.
not responding to them.
What made this exchange significant was not simply the accusation at the end. The real disagreement began much earlier and centered on a question that has followed the Epstein case for years. What information remains undisclosed, and why? Congressman Dan Goldman approached the hearing from a position of skepticism regarding the government's handling of Epstein-related records. His argument focused on transparency. Specifically, he questioned whether federal agencies had released everything that could legally be made public. The hearing began with a direct question regarding whether Donald Trump's name appeared anywhere in the Epstein files. Patel's response was notable because he immediately framed the issue around legal limitations. Rather than focusing on specific individuals, he emphasized that information had been released to the extent permitted by law. That distinction shaped the rest of the exchange. Goldman's position appeared to be that legal restrictions were being cited too broadly. Patel's position was that court orders, protective orders, victim protections, and other legal constraints limited what could be disclosed. This disagreement is important because the two men were not necessarily debating the same issue. Goldman was focused on whether additional material could be released. Patel was focused on whether the FBI had authority to release it. Those are related but different questions. Throughout the hearing, Goldman repeatedly challenged Patel's interpretation of the legal barriers. He questioned whether certain records remained protected. He questioned whether witness interviews could be disclosed. He questioned whether investigators had pursued every available avenue to make additional information public. Patel consistently responded by emphasizing legal restrictions and prior reviews of evidence. One of the most important moments involved discussion of videos and photographs collected during the investigation. Goldman suggested that certain materials could potentially reveal information about additional individuals connected to Epstein. Patel pushed back strongly against that suggestion. He stated that the overwhelming majority of seized materials consisted of downloaded pornography and child sexual abuse material that would never be publicly released. This portion of the exchange highlights one of the major challenges surrounding public discussion of the Epstein files. Many people use the phrase Epstein files as if it refers to a single collection of documents. In reality, the materials encompass many different categories of evidence, including witness statements, investigative reports, court filings, photographs, electronic records, and highly sensitive materials involving victims. Different categories of records are subject to different legal standards. Some may be publicly releasable. Others may be restricted indefinitely. Still others may require court approval before disclosure. As a result, public debates about transparency often become disputes about what specific records are being discussed. That dynamic was visible throughout this hearing. Goldman repeatedly attempted to narrow the discussion toward particular categories of records. Patel repeatedly returned to broader legal constraints. Neither side appeared satisfied with the other's explanations. The discussion then moved toward witness interviews, commonly known as FBI 302 reports. This became one of the most contentious portions of the hearing. Goldman argued that these materials were not subject to the same limitations as certain other records. Patel responded by emphasizing court orders and protective orders. At that point, the disagreement became highly technical. Rather than debating facts about Epstein himself, the conversation shifted into a dispute about legal procedures, sealing orders, and disclosure authority. For many viewers, these procedural arguments can be difficult to follow. However, they are often central to major investigations. Public frustration frequently arises when agencies claim they cannot release information, while critics argue that additional disclosure mechanisms exist. This tension is not unique to the Epstein case. It appears in investigations involving national security, organized crime, public corruption, and many other sensitive matters. The difference here is that Epstein remains one of the most controversial figures in modern criminal history. As a result, every dispute about records attracts enormous public attention. The most dramatic moment occurred near the end of the exchange. After several rounds of back-and-forth questioning, Goldman directly accused Patel of hiding the Epstein files and being part of a cover-up. That accusation transformed the discussion. Up until that point, the disagreement had focused largely on legal interpretations and disclosure practices. The accusation elevated the debate into a challenge to Patel's credibility and motives. Patel immediately rejected the claim. He described any suggestion that he was protecting child traffickers or concealing information as categorically false. That response reflected the seriousness of the allegation. Accusations of a cover-up are fundamentally different from disagreements about legal procedures. One concerns interpretation of the law. The other concerns intent. The hearing did not produce evidence proving either side's broader claims. What it did reveal was the extent to which trust has become a central issue in discussions surrounding the Epstein investigation. For critics, unanswered questions continue to fuel skepticism. For defenders of the investigative process, repeated allegations of concealment ignore years of investigations, prosecutions, court proceedings, and evidence reviews. This is why the Epstein case remains politically and publicly significant years after Epstein's death. The debate is no longer only about Epstein. It is about transparency. It is about institutional credibility. It is about whether the public believes that powerful individuals receive the same scrutiny as everyone else. Goldman and Patel represented two very different perspectives on those issues. Goldman argued that additional transparency is necessary. Patel argued that legal restrictions and prior investigations have already established the limits of what can be disclosed. The hearing did not resolve that disagreement. But it clearly demonstrated why public interest in the Epstein files remains extraordinarily high. As long as questions remain about what records exist, what records have been released, and what records remain protected, exchanges like this are likely to continue drawing attention from lawmakers, journalists, victims, and the public alike. And that is ultimately why this confrontation mattered. The hearing was not simply about documents. It was about trust in the institutions responsible for handling them.